Hi, Timothy Brown back again with Mariana Bracic of MBC Legal.ca, specializing in proper written employment contracts for healthcare practitioners across Canada. Mariana, our company, amongst many others, and many of our clients are trying to implement and are planning to implement proper written employment contracts with the help of your firm, which specializes in this. Now, some owners are a little bit cowardly and we're a little nervous about approaching our staff, and I'm not excluded from this. What happens when an owner goes to long-term staff members in particular and they refuse to sign? They say, I'm not signing a contract, and they will not sign under any circumstances. What happens? What are the mechanics of this, and how does this affect the owner, the employee, and the business?
Okay, that's an excellent question. It's probably at least the second most common question that we get. From a legal perspective, if the process of transitioning to what we call the practice protection package, so proper contracts and policies,
right,
if that process is handled properly, which of course is our specialty to do, so it's our job to do that, but there are risks in doing it, so it's very, very important that you work with someone who does this day in, day out, because we see it fumbled all the time. Having said that, if it's done properly, the employee really has no choice. We give them all that they are entitled to at law, which is reasonable notice in advance that their current, largely unwritten, common law contract is coming to an end on a certain date. And they have, and we write, lovely soft letters to them, letting them know that on the advice of the RCDSO and their lawyer and all their professional advisors, they're doing this proper process. And so each staff member has a certain amount of time to sign back. We'd love it if they'd sign back right away, but in the short term, it's really voluntary. However, beyond such and such a date, which date we calculate for each staff member, they must sign it back if they want to stay there. And if they don't sign by that deadline, then their employment has terminated, and it's what we call a rightful dismissal. It's a dismissal on proper notice in advance. And if they, in the very unlikely event that they don't want to sign it, we owe them nothing more. We've already given them what the law says we have to give them. And that's it. It's their choice, but if they walk away with nothing.
So, as I understand this, now I'm an employer. I'm speaking for myself right now as an employer. I'm protected no matter what.
Absolutely, that's exactly
I've done
right.
everything as the law requires me to do.
That's exactly
I've honored
right.
all the obligations that I am responsible to give to this staff, or an individual staff member. And if they refuse to sign, I'm still protected.
Yes.
I still have rights. And the employee has been given all that they are honored and entitled to.
Yes, and in a way you've been tipped off that had you not done this process, this is likely someone who would have cost you a great deal of money, possibly 6 figures.
So, introducing proper written employment contracts to your staff not only protects you when they sign, but also protects you if they don't sign.
Right, exactly. Exactly.
Okay, that's good. Timothy Brown and Mariana Bracic, thanks for watching.